note satisfaction to the reasonable, fair and just and all that.
But when you made the notification for cooperative societies in June 2017, it must have been exercise of power under section 4(1) Roman 2, because it says such class of persons.
Such class of persons. That's right. Therefore, it was
under which provision you did it? It must have been under 4(1) Roman 2.
Such class. That is a widely word. Such class of person.
Yes. So you have done it for a particular class of persons.
Correct. So
that's not under subsection 2. That is under
subsection
4(1) Roman 2.
Subsection 2 comes later.
Yes.
The court will not take a microscope and say, look here, what is this figure missing? Is the figure wrong? Is the figure doubtful, etc. So that perhaps will not be taken by the court. Trying to gather the number of applications which RBI has received. More than 700 odd applications.
Use the mic, I think. Switch on.
More than 700 odd applications.
700.
To be considered under subsection 2. So many of them have been considered, and the RBI is not in a position to say I'm able to accede to a request for acceptance. So unless I have a comprehensive, there are a large number of applications there, representation, whether they have been considered, what reasons given, I need to have a second look into them. I don't want to give a commitment. But one thing is that the government of India is very clear that they would not like to extend the window open for any further period, because then it introduces any amount of uncertainty in increasing the consideration point aspect of the RBI. On that I am very clear. But within those cases where RBI could do, if at all, on his satisfaction, whatever they may do, subject to a loss of direction, that's a different issue altogether. But the government of India is just not going to say that we'll extend the date and thereafter applications will be received afresh. That will be an endless uncertainty, opening up the backdoor entry for again. Yes. Another exception, Article 40. Therefore, any number of those circumstances when people may have the bona fide background, but to say that we will have a series of exceptions granted to the extension of time will be certainly introducing an endless uncertainty. That will be going to be unmanageable. Then those who are otherwise knew that they could have done it now will stand as I'm told there are certain temple trusts who receive a lot of money and they want to get it in cash. So these are the kind of uncertainties which will come.
Is the power vested in you under subsection 2 of section 4, and that power has to be exercised subject to your satisfaction. So if an element of satisfaction and discretion is vested with you, there is also a duty to decide it in accordance with
correct. Let me
particular case is genuine or not. And even if you are in a genuine case, you are rejecting their claim, then it will be an arbitrary exercise of power.
Large number.
Answer it.
Yeah, whether I would like to answer, of course.
No, not now.
Only one thing I would say, my lord, we have communicated that according to us, 4(2) is, my lord, in exercise of the power under 4(1).
Plain reading would not show that.
My lord, I'll try to, my lord, show you.
All right.
It's not a separate power.
Yes, Attorney. Now, before we go into notification, there are two stages. I just read quickly with the power coupled with the duty and all that submission. Well, if you are going to take away a property compulsorily, and there is no mechanism by which this acquisition is compensated, then what are that you are doing? So one may read a power coupled with duty to ensure that there is an exchange provision available. That's available under the Act. There is an exchange provision available under the Act. Therefore, there is no acquisition of property at all. If the exchange provision has not been available in the Act, then Article 300A, all those issues will come.
Exchange provision up to a particular date.
That's right. Therefore, then comes the next question. Where do you draw a line? On that question of drawing a line, will there be an objective criteria, racial criteria, or will be subject to any number of requests that may come from any number of quarters? It has to be some criteria on the basis of an understanding of the government to say that I am pushing this immediately for certain considerations and reasons, the object to be pursued. On that, I don't think there can be any controversy. You can choose a date 1 week later, 1 month later, or 1 week earlier. I don't think that consideration will ever fall for a judicial review issue. Large number of decisions said that date will always have some exceptions here and there. Unless there is a pick and choose or a malafide. So I don't think we'll also get into that question.
Let us take a case of one of the petitioners,
yes,
whose husband was in coma, he died after a cut-off date. And after his death, he recovered that. Such
therefore, those kind of cases, I understand that. Those kind of cases on the fringe, if I put it like that, if RBI has that reservoir of power under subsection 2, and a notification says we can do that, then it is entirely within the scope of the RBI. That's right. For I'm not discounting that at all. Maybe those cases will call what they call, even if you rule, sometimes a person may have an application for a deviation from the rule. In Rama Sugar Industries versus State of Andhra Pradesh, the Lordship said you may have a rule, a principle or a policy, but in a given circumstance, somebody may have a genuine application. The authority may have to oblige to consider the application. That's a different issue altogether. That may be read into subsection 2.
That is what we are saying.
That's right. Beyond that,
we are not asking you to extend the date under subsection 1 of section 4.
That's right. Therefore, that we are very clear. Lordship, the extension of date is certainly not a matter of a negotiation. Then within that subsection 2 power, if those fringe cases can be considered subject to the satisfaction, so certain consideration will have to be fulfilled by the applicant. So it is entirely, your Lordship may add something to this, how this RBI may consider them, it's a different matter. I may not certainly restrict what can be done in order to complete that.
You would also not like to open a Pandora's box.
That's right.
But if there are genuine cases, like Mr. Diwan's client,
there I may have something to say.
Yeah.
and I have something to say.
Whether the reasons given are genuine or not, that is the subjective satisfaction of the RBI.
That's right.
We cannot sit in and appeal over that. But then they will have to take into consideration relevant factors and arrive at a subjective.
That can never be shut out. That question can never be shut out. But how they will exercise their consideration and what satisfaction they will arrive, except again the law is well settled. Satisfaction will be reasonable.
When is very reasonable?
It's a case to case. I as a government of India, I cannot say I will consider all the applications that happen.
Like somebody said that he had 3 crores of cash.
That's why I said there are temples who receive large amount of donations and they want to come out. It is nobody's money, but then they will claim. So black money coming in is kind of,
That's all. Therefore, the language employed in that 4.2 is subjective satisfaction. Read that provision.
If satisfied.
If satisfied. So it is for them to take a call, It is for them to take.
If satisfied.
If satisfied. These expressions are
and genuine.
That's right. If satisfied would include genuineness.
Yeah, satisfaction also is not left to their own whims and fancy.
Your Lordship knows satisfied has received his judicial concession, well known, satisfied from the reasonable, fair and just and all that.
But when you made the notification for cooperative societies in June 2017, it must have been exercise of power under section 4.1 Roman 2. Because it says such class of persons.
Such class of persons. That's right. Therefore, it was.
Under which provision you did it? It must have been under 4.1 Roman 2.
Such class, that is a widely word, such class of person.
Yes. So you have done it for a particular class of persons.
Correct. So
that's not under subsection 2. That is under
subsection
4.1 Roman 2.
Subsection 2 comes later.
Yes.
That's right.
No, but you have done it.
That's right. I'm not saying there is a notification.
And you did it 6 months later. In 2017.
Notification, you're not right. Notification takes care of non-residents, residents, non-residents. That's why they are subsequent notifications.
So that must have been exercise of power under 4.1 Roman 2.
That's true. There is no difficulty about that.
Yes.
But after such a notification, whether RBI will come in, that will come in only under subsection 2. That's a different issue altogether. The two stages are different.
No,
suppose I'm not.
Notification itself came beyond 31st December, beyond March, etc.
I'll take another case like this. Suppose there was a class of persons who would otherwise be entitled to make an application, and I have not issued a notification covering them. Somebody may have a case against that. That's a different issue. But here we don't have those issues at all. It's only a question of subsection 2, satisfaction of RBI and how they can go about fulfilling this duty.
So, prima facie, you agree with your submission on that?
I am only saying there is a statutory avenue open and the statutory avenue will be exercised. I am not making any concession on that because there is a statutory avenue available. And only since all is getting brought before the court and the court has also expressed its concern, of course, the exercise of power under subsection 2 will be.
What is your answer to the main submission on exercise of powers under subsection 2 of section 2?
I'll presently address that question, section 26 too, because I have some other submissions.
That is the main legal issue.
I have some submissions to make before I come to the question. There are 3 sets of affidavits filed by the Union of India over a period of time. And tracing the history over a period from 2014 onwards, what is this application of mine and material studies, surveys conducted, so on and so forth. And we also put on record in the current affidavit the connection between demonetization, the tangible, intangible, direct, indirect benefits. How do you get it connected? And the Union of India says don't look at demonetization in isolation. It is not a standalone measure. You don't look at it as only an exercise of power under 26(2) and don't reduce it to that issue. It is a larger ramification. And how do you connect it? I'll try to address your lordship on that. Then the second aspect is, look at the role of a central bank. Central banks all over the world, from 1642 central bank alone. You look at the trajectory of their role, functions, etc. Broadly, a monetary policy. And the monetary policy again is not to be looked at as a monetary policy which can be dealt with without being connected to the economic policy of the country. So they're also intrinsically connected. So in the evolution of monetary policy and the operation of monetary policy, we have again in current standards. I was just reading a book written by the one-time governor of the Central Bank, Federal Bank of USA. So look at the growth trajectory of the function, the inflation control, inflation management, in monetary policy, interest rate, cutting interest rate, enhancing interest rate, so many things which come in the entire gamut of this monetary policy. Therefore, you can't probably define within a very close limits. The bank will have to operate only in this manner. With capped and confined, you can't do that. So this is how the functions of RBI may have to look into. Having said that, kindly take copies of the written notes. Lordship, may kindly take, may quickly take my written notes. I've culled out from various affidavits for the purpose of the Lordship's convenience. One broad submission I'd like to make is the kind of data, statistics regarding notes in circulation and fake currency, etc., will be a broad guidance. The court will not take a microscope and say, look here, what is this figure missing? Is the figure wrong? Is the figure doubtful, etc.? So that perhaps will not be undertaken by the court. What I'm trying to give from the various affidavits is the direct benefits from as far as reduction of fake currency. As per the newspaper report, the measure resulted in the destruction of the fake currency in the hands of the holders. This amount is difficult to quantify. The holders of counterfeit notes were thus stopped from continuing to put the fake currency into circulation. Total number of counterfeit notes in circulation decreased sharply from 7.62 lakh notes in 2016-17 to drop to 90,000 notes in September 2021. So you can't say, look here, the notification came in November, it should have happened immediately thereafter. There's no calibration to do that. Then counterfeit currency dedicated in the banking system is reported by RBI is currently detected in the banking system. Other law enforcement agencies also provide values of seized banknotes. Overall, the exact magnitude of fake currency could have been much higher than reported. The overall trend indicated that demonetization extricated the fake currency significantly from the system. Is this not a value which the court will definitely address while looking at the measures taken by the government over a period of time? So the extricating is very important. The quantum of extrication may not be so important, because that's again a huge thing outside the hands of any planning authority or a governance. The enemy is standing outside grinning at us. I can play with you because fake currency and black money are such enemies you can't easily identify and put your hands on. They wear masks all the time. Therefore, it's easy to say that look at rational standards, how much you have detected, how much money has come into the banking circulation. All that question will better answer by saying, look at the complexity of those who are waiting outside the formal economy and trying to render the formal economy and then derail it. So these are the concerns government will take into consideration. Let me read further. Significant pickup in the fake so-and-so detections reported in the banking system, as I pointed out. 2015-16, preceding withdrawal of legal tender, 6.3 lakh pieces. Then 2016, it was detected to be 7.6 lakh pieces. After withdrawal of the legal tender status of so-and-so, steady and significant decreasing trend in the fake currency detection report by RBI. So you look at 2020 when it's 2.1 lakh pieces. In terms of value of counterfeit currency, 43.47 crores of notes were detected in so and so, which progressively reduced to 5.5 crores in 2020-21. It's not arguing.
Only submission you have made counter to the other side is these are all economic policies, don't touch. That's all so far you have said. What is your legal
I'm only trying to find out why
that's all right. What is your opposition to the plea of the other side? Please tell us. Your only submission, as we understand from this, this first submission notice.
Yes.
These are all economic policy. Experts have done it. Don't touch. That's all.
That's a broad proposition.
Then tell us. You point out what you must. What is your argument? How do you counter their submission?
No,
for example, they said it is not in conformity with section 26(2).
Come to section 26. I'll immediately come to it. I'll just come to it.
That is the main argument they have canvassed. That is the
argument on 26(2) is premised
how you have
on certain framework of facts.
That's all right. What point you meet the points one by one.
Your now argument appears to be since we have now enacted a 2017 Act, don't touch our action under 26(2).
The notification, I think it's a very legitimate legal argument. The 2017 Act has come into position. I'll read the 2017 Act, section 3 and 4.
No, maybe this what you have now given is almost to say that the object has been achieved kind of thing. First you should show the contention which was there, whether the procedure was followed rightly or not.
I'll definitely come to that. I'm not going to skirt that issue at all. The procedure to be followed, I'll share the information also, nothing to hide from the court, everything is clear. But I want to lay down a foundation for what is sought to be said. How do you look at section 26? If you want to look at section 26 as an standalone provision and as any other statutory provision, then we are probably going in a wrong direction. I want to say, see the scheme of the RBI. Look at 26. What is the place which occupies in the entire RBI scheme of the powers and function given to RBI? Unless we look at that, 26 will not probably get its proper light and in construction. Therefore, I'm trying to place all this background. So how do we really look at it? I'll certainly come back to section 26 in a few minutes. And if may I then read this note a little later.
No, we will leave it to you, but please answer their question.
I'll definitely.
Please respond to what is.
I think just then take section 26 for a minute and the RBI Act. Before, may then complete reading this note which I have given and then come. My broad submission on section 26 would be look at the entire scheme of a string of provisions in the Reserve Bank of India Act and what's the role of a central bank and how it discharges its functions and what amount of responsibility it is called upon to act in the section 26. And if you want to introduce certain pedestrian considerations on looking at an ordinary statute, either a recommendation, either a consideration, either a consultation, well, then you are going to reduce section 26 to a very narrow area where the entire complexity of management of currency monetary policy will be stultified. That's why I thought I'll place a larger pact framework and then come to section 26.
No,
I'm sure I'll be able to pursue lots of the way section 26 should be read and understood. In order that the integrity and the scheme of the RBI is kept intact. We are talking about an important legislation for the entire monetary policy of the country. It is not any other statute. Therefore, certain considerations may have and invoke for the purpose of reading any other statute, giving a little flexibility, liberal reading, purposefully, etc., probably may not be helpful in the context of a statute like that.
So we are looking at section 26 in the context of central banking functions, chapter 3. It is a central banking function with regard to section 26.
Note.
Yes.
In case of high denomination banknotes 500 to 1,000, counterfeit currency. Therefore, we are looking at the symbiotic connection between the government and the RBI. If you want to sever them and put them in compartments in isolation and say that RBI must first apply its mind, never in touch with Government of India, never in consultation or having any correspondence, but must do his own job, then come and tell government, look here, I have a recommendation, will you consider that? I think I have a small difficulty in that construction. That's why I'm trying to take laws to look at the complexity of the power now imposed on the functions in charge of the RBI under this very challenging circumstances. That's why you said don't give it a cribbed, capped, and confined construction. Give it a very flexible construction, a wide construction.
No,
Now let me take the losses further on that and
the argument was,
I'm sorry.
Mr. Attorney General, the argument was that the Act recognizes the expertise of the persons in the RBI, and it is that expertise which must recommend to the central government. The Act recognizes that. Central government, we are not saying is bound by that recommendation or not bound by that recommendation. We are not at that. We are at the position of where it should emanate. No doubt there must be symbiotic relationship, all that is there. But the legislation is not like that. Legislation recognizes the expertise of the Reserve Bank board, the application of mind by the central board to the central government. The argument is, where is that?
No, my argument is not that RBI's role has to be minimized. It doesn't have that kind of role. Its application of mind is of no consequence. I'm not saying that. I only trying laws to appeal to look at the. That's why I use the word symbiotic connection. It's a very organic connection between government and RBI.
They have to work in sync with each other.
That's I think very important. I will not listen to you at all. I will not lend my ears to you. And I don't think that's the way in current contemporary times. Your monetary policy, its evolution, its integrity, its cohesion, all that will have to be kept in mind. Therefore, that's why I tried to lay this very broad framework, and that's very important consideration. Now, kindly turn to page section 7. The central government may, from time to time, give such direction to the bank as it may, after consultation with the governor or the bank, considered necessary in the public interest. Subject to such directions, the general superintendent in direction of the affairs and business of the bank shall be entrusted to a central board of directors, exercise all powers and do all acts, things which be exercised by done by the bank. So and so, provided regulation made by the central board, the governor shall have so and so nominated powers of general superintendent. This power to give directions probably will find in many statutes where the central government or a state government can always give directions to an authority, statutory authority. But it also occupies a slightly different connotation from what I propose to do. Then kindly turn to now section 17. These are the kinds of business with the bank shall be authorized to carry on and transact the several kinds of businesses hereinafter specified namely. And we'll also look at the kind of businesses which have been added over a period of time. They are very valuable additions. And maybe if you look at it very closely, some of them seem to be unconnected, but they have a certain connection. So the functions of the bank which have increased over a period of time are also on the basis of the experience gained at what important role a central bank will play in the national economy. The bank shall undertake to accept monies for account of the central government and to make payments up to the amount standing to the credit to the account and to carry out its exchange, remittance and other banking operations, including the management of the public debt of the union. That's where 20, 22, 34, etc. may come. The bank shall have the sole right to issue banknotes in India, made for the period which shall be fixed by the central government on the recommendations of the central board, issue currency notes of the government of India, supplied to the central government, and the provisions of the act applicable to banknotes shall unless so and so apply to all currency notes of the government of India, issue the central government or by the bank like manner, as if such currency notes of banknotes and reference and so shall be construed accordingly. Then 23, issue department. The issue of the banknotes shall be conducted by the bank and issue department, which shall be separated and kept wholly distinct from the banking department. And the assets of the issue department shall not be subject to any liability or the liabilities of the issue department defined in section 34. Then kindly turn to section 24. Subject to the provisions of subsection 2, banknotes shall be of denominational values of 2 rupees, 5 rupees, 10 rupees, 20, 50, 100, 500, so on and so forth, not exceeding 10,000 rupees that the central government may, on the recommendation of the central board, specify in this behalf. The central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of banknotes of such denominational value as it may specify in this behalf. These are conceptually different from section 26. Then 26. Subject to the provisions of subsection 2, every bank note shall be the legal tender at any place in India in payment on account for the amount expressed therein and shall be guaranteed by the central government. For two concepts, it shall be legal tender and guaranteed by the central government. If in the absence of section 26(1), so the question of bank notes and their legal tender will not arise. Therefore, here is the most important provision in the RBI Act. Then having given the power to issue bank notes, should it stop there? So should it leave to an imagination or to an unoccupied field for the RBI to deal with? Once you have issued bank notes, what do I deal with them? If I want to deal with them later at any point of time, having regard to the monetary policy demands. So subsection 2 is very important. On the recommendation of the central board, the central government may